Okay, everybody. So we're going to go ahead and get started. I'll keep admitting people as they show up, but I want to thank you all for coming this evening, for joining us on the Zoom. This is a really important and timely topic for everything happening in higher education. And we're going to cover tonight, what does the SCOTUS ruling mean for DEI in higher education? We are going to be, our presenter this evening is Professor Timothy Welbeck. He's the director of the Center for Anti-Racism and a professor in the Department of Africology and African American Studies at Temple University. Also a civil rights attorney by training, and he is a law, race, and cultural studies scholar. So I think we have the perfect person to speak on this topic for us tonight. And so without any further commentary from me, I'm going to go ahead and turn it over. Kaiser, if you have anything to say beforehand.
Thank you, Janine. Thank you, everyone. Welcome, everyone. Welcome, Professor Welbeck. Thank you for joining us.
Well, thank you so much for having me. Before some of you all came on, one of the things we're talking about is that it's remarkable that so many of us are coming together on a Monday evening for this topic. And so I appreciate your interest and your enthusiasm and the like. As it was said in my introduction, my name is Timothy Welbeck. I'm the director of the Center for Anti-Racism. This is a timely topic. It's one that impacts not only our university, but institutions across the country. And so if you don't mind, I am going to share my screen and walk a little bit through a PowerPoint talking about some of these issues and the like, and then hopefully we'll leave some time for some questions after that, and then go from there. No, that's not what I want to do. So tonight we're talking about the most recent Supreme Court cases around affirmative action. And in a lot of ways, this history is a protracted history. And a lot of people look at the Supreme Court cases themselves dealing with affirmative action and even the executive order that gave the cases the executive order that led to affirmative action and even the use of the term affirmative action. But in many ways, these cases, this policy is about a broader conversation around educational access. The title that I gave this is The Missed Education. It's an allusion to Carter G. Woodson's The Miseducation of the Negro. It's his foundational text. And in it, he talked about how in educational institutions across the country, Black children were receiving an inadequate education. Either the institutions where they attended were inadequate in terms of the resources when compared to their white counterparts, or they were receiving an education that inculcated the sense of inferiority within them. And so in that way, he said that the Negro child, which was the term at the time, was miseducated. Here we see Thurgood Marshall, whom many call the man who killed Jim Crow. It was a team effort, but he gets a lion's share of the credit for it. But in a lot of ways, he helped to execute the strategy that helped to bring forth the precedent that unended segregation in the United States. And it was with Brown versus Board of Education of Topeka, Kansas, which helped to open up not just educational institutions, but institutions across the nation. And so I thought it was important to begin our conversation about affirmative action with just an acknowledgement that this is a broader conversation around educational access. Who has an opportunity to engage in some of or who has the opportunity to access some of our most prestigious institutions. As it relates to the actual decision itself, Justice Ketanji Brown Jackson issued what many consider to be a extraordinary dissent, whereby she acknowledged that, among other things, that the decision to undo affirmative action not only undid decades of precedent, but it also was a tragedy for us all in that we were robbed of an opportunity for a policy like affirmative action to achieve its ultimate aims and the like. The cases itself are a consolidation of two different cases. They were brought by a organization called Students for Fair Admission. They consider themselves to be an advocacy organization that, and by their estimation, is seeking to bring about racial equality by removing considerations of race, particularly in higher education, but ultimately they want to unravel race as a consideration in all of our institutions, both in educational settings and professional settings and alike. Without getting too much into the weeds, the cases were brought against two institutions. One obviously is Harvard, the other is UNC. The two cases were brought for a number of reasons, but they're related. Ultimately, the Students for Fair Admissions wanted to both attack multiple legal arguments, but they also wanted to attack different types of post-secondary institutions. So you get an elite post-secondary institution that's private, an elite post-secondary institution that's public, but they also brought forward two legal arguments. In the case brought against Harvard, there was this argument that Title VI of the Civil Rights Act of 1964 was violated, and that the Civil Rights Act prohibits discrimination on the basis of race, particularly in public accommodations, but in other institutions across the United States. And so Title VI is the one that's specifically honing in on racial discrimination. And the case brought against UNC was arguing that the admissions policies of UNC were violating the Equal Protection Clause of the 14th Amendment. 14th Amendment guarantees, among other things, equal protection under the law. And so the two arguments were, in the instance of Harvard, when Harvard was considering race as a factor among many in its admissions process, they were arguably discriminating against white people and Asian Americans. That was the argument. And in so doing, the allegation was that they were bringing forth an active form of discrimination which violated federal legislation. As an aside, it's deeply ironic, and some would even argue sinister, that a federal legislation that was used to combat racial discrimination against Black people was ultimately used to undo a policy that was seeking to undo the harm done to Black people in post-secondary institutions. But that's a conversation for later down the line. In terms of UNC, the argument was that both white applicants and Asian American applicants were not receiving equal protection under the law, in part because the University of North Carolina was favoring Black, Latinx, and Indigenous applicants. At least that's what the argument was. The Supreme Court, as we all know, held in favor of SFFA, Students for Fair Admissions, and said that Harvard's admissions and UNC's admissions program violated the Equal Protection Clause of the 14th Amendment. And so with that, what is affirmative action? So the actual term itself comes from an executive order that President Kennedy issued in 1961. And the executive order was around achieving some various forms of racial equity within the workplace. Specifically, it was designed to prohibit discrimination on a basis of race, creed, color, or national origin. And it also encouraged employers and employees to engage in affirmative action to ensure that all people in the workplace were treated equally, regardless of their race, creed, color, or national origin. That's where we get the phrase affirmative action from. In 1967, the phrase itself and the policy itself was expanded to include women as well. And ultimately, what began as a policy to establish a form of equality in hopes of later maybe achieving equity in the workplace was expanded to post-secondary institutions. As it relates to that, oftentimes there are conversations around what affirmative action is, and most of them are steeped in misinformation. And so it's important to talk about what affirmative action actually is or was, as we talk about the history that helped to affirm it, and then ultimately the precedent that has undone it. There is a law professor at Georgetown, Professor Francois. While these conversations were fomenting and during the oral arguments on social media, he asks this question, and I think it's a salient one, in that he says, when it comes to higher education, what does the U.S. owe Black Americans for the harms of slavery and apartheid? Now, while affirmative action itself may not have precisely worded it that way, ultimately, that was the question that it was seeking to answer, and one that the courts have been seeking to answer for more than a century. Affirmative action was initially designed as a corrective measure. It was considering the fact that the United States had engaged in routine and flagrant discrimination designed mostly to disenfranchise Black people. And once it acknowledged that, then it was a matter of what can be done to mitigate the harm that was done by those actions. And so that's why many critics of the implementation of affirmative action over the years have talked about that when you're initially charged with remedying past inequities and hoping to mitigate the harm that was done by those inequities, if you're shifting or moving the goalpost to talking about achieving diversity, you're becoming short-sighted and not getting the actual outcome that you intended. Additionally, many elite post-secondary institutions are not the meritocracies that they often herald themselves to be. One of the named plaintiffs in these suits, Harvard, by way of example, when you look at their incoming class, a significant number of their incoming class are either people who are legacy admissions, meaning that they are related to someone who has graduated from the institution, a student athlete, or a relative or an associate of a substantial donor to the institution. For the most part, none of those things deal with meritocracy. I think you can make an argument possibly for a student athlete. But if you're looking at the admitted class, the legacy admissions alone for white admitted applicants exceeded the entirety of all admitted Black students. And so when we're talking about meritocracy, there are considerations that have been made over time that don't necessarily deal with merit. Affirmative action over the course of its history, particularly in post-secondary institutions, most benefited white women. And it's something that studies have revealed over the course of the past several decades. And lastly, affirmative action in and of itself did not have the time in which to achieve its desired or stated goals. If you look at the grand scope of affirmative action as a whole, and look at the grand scope of segregation, both in post-secondary institutions and just institutions at large in the United States, the window of time in which affirmative action was permitted, it pales in comparison to this larger, broader history. When we're looking at affirmative action itself, there are a series of cases that help to establish the precedent that was ultimately undone last summer. The first of which is Regions of California versus Bakke. This is the initial signature case dealing with affirmative action. And so, like I mentioned earlier, affirmative action begins as a mechanism to ensure various forms of equality in the workplace. Very quickly over time, it expands into, by the time we reach the early 1970s, we're beginning to see post-secondary institutions including various forms of affirmative action and their admissions practices as a means to comply with this broader federal policy in the workplace. And so the University of California engaged in that practice. And one of the things that they did at the time was they had a quota system whereby they had a set aside number of spots for admission for students who hailed from a racial minority. And so for every 100 applicants, 16 of those were set aside for a racial minority. Bakke was applying to medical school. He applied to a number of medical schools, actually. He actually didn't get into any of them. As an aside, many legal scholars talk about that he actually had a potential novel case for age discrimination because many of the medical schools that he applied to felt as though he was too old to begin a medical career, and some of them admittedly denied him for that. He did not bring a claim on the basis of age discrimination. but he did bring a case against the University of California for race discrimination. And again, he was denied admission to multiple institutions, but he only sued the ones that had these racial quotas, considerably the University of California. And so the Supreme Court, in their decision, one of the things that they do is they say that the quota system itself, the set-aside program, was unconstitutional. You can't indicate a certain number of positions that you're going to set aside for a group of people, even if your stated aim is a notable one. But instead, you can consider race among many factors, is so long as you are trying to meet the compelling interest of, in this case, remedying past harms that are related to racial discrimination. And so this first case begins to set the stage for the legal framework that will later on become decades of precedent, and that schools in and of themselves can't have a quota system, but you can consider race in such a way that it's allowed to pass a legal test called strict scrutiny. It's the highest level of scrutiny that a piece of legislation or policy can undergo under the law. Over time, affirmative action was challenged multiple times throughout the decades. Some notable cases come in the 2000s and the 2010 and the 10s. So some companion cases are coming or came against the University of Michigan, against their undergraduate program and their law school. So there are cases, companion cases. One is called Gratz v. Bollinger, the other is Grutter v. Bollinger. Gratz v. Bollinger brought suit against the undergraduate portion of the university. At the time, the undergraduate admissions program had a point system that they created for applicants. Anyone who scored 150 or above was someone who was considered favorable for admission. And so that numeric calculation, those points were awarded for an array of different things: grade point average, extracurricular activities, recommendations, things of that nature, standardized test scores. But another factor were things that the university felt would be beneficial for bringing into the student body. So they consider things like regional diversity. If you were from a region that did not typically apply to the university, you could be awarded points for that. If you were a student athlete, you could be awarded points for that. If you were a racial minority or a potential religious minority, you could receive points for that. The way the system worked is once you started getting into some of those ancillary categories, you could only get points for one. So if you're a racial, religious minority who's a student athlete from a regional place that's diverse for their applicant pool, you can only get points for one of those categories, whichever of those categories would award you the most points. And so that was their system that they had in place. And similarly, or dissimilarly, the law school had a more ambiguous consideration, in that they would consider race among many factors in their admissions pool. And so as they're making admissions decisions, they would look at an array of different things: standardized test score, GPA, recommendations, extracurriculars, job experience, things of that nature. And then ultimately, they would consider, if all things being equal, race among these other factors. What ultimately happens is these cases go before the Supreme Court. The Supreme Court finds in Gratz v. Bollinger that the point system for the undergrad of University of Michigan was unconstitutional. In short, it was too close to the quota system of Bakke versus Board of Regents of California. And so as a consequence, the Supreme Court ruled that in and of itself was unconstitutional. And so with Grutter v. Bollinger, there was this larger consideration or conversation around the notion that race, among many factors, was still constitutional, and that it met the standards that could surpass strict scrutiny. This complicated legal test that challenges or interrogates laws and policies and things like that. It has a compelling interest, which is one of those considerations. It doesn't unduly burden applicants, which is another one of the considerations, things like that. It complied with prior precedent, all of these types of things. And so Grutter becomes the law for most of the time that we have affirmative action remaining, and that it helped to whittle down some of the arguments and more fine-tunedly begin to articulate what is constitutional in the grand scheme of things. Fisher versus Texas is a series of cases, the first of which was decided in 2013. It was decided in favor of the University of Texas and remanded to lower courts for other considerations. They brought it back up to the Supreme Court. Supreme Court decides in 2016 that case. University of Texas had, or Texas as a whole had a system, and University of Texas implemented it, whereby if you graduated at the top 10% of your class, you received automatic admission to the University of Texas, which is the flagship public institution in the state. For the remainder of an incoming class, they followed the holding of Grutter, and that they would consider a race among many factors. Abby Fisher was an applicant who did not get into the University of Texas. She did not graduate in the top 10% of her class. She also did not get admission from this broader applicant pool either. So she sues the University of Texas. Like I said, she was unsuccessful. And so in many ways, the affirmative action, the law around it was pretty much cemented. And that's why when the Supreme Court agreed to hear students for fair admission against Harvard and students for fair admission against University of North Carolina, many legal scholars knew that affirmative action was in its last days, because the legal arguments in and of themselves had not fundamentally changed. Most of the facts surrounding the applicant pools, for the most part, had not changed. There were novel differences here and there, but the overall factual patterns leading to some form of litigation were effectively the same for the last 25, 30 years. So when you look at that, when you look at the law in and of itself had not fundamentally changed, many people speculated and were correct in saying that because the composition of the court had changed, the court was likely to change its decision as to what was admissible or what is constitutional as it relates to affirmative action as a whole. And so as a consequence, we see that affirmative action was overturned. One of the things that happens in Students for Fair Admission versus Harvard and Students for Fair Admissions versus UNC is that for the most part, universities, post-secondary institutions can no longer consider race among many factors as a positive for an applicant. Military institutions were written out as an exception. There's a current litigation challenging that exception right now. And of course, current terms, so we'll see if that exception gets overturned. But effectively, universities, colleges, all forms of post-secondary institutions, the question remained then, what are you going to be able to do if you have a value for diversity, if you understand that there are institutional and structural harms that have impacted some of your applicant pool from before, and because they might hail from some of these communities that have been disenfranchised historically, what are you going to do about these things? And so Temple University is actually one of the universities that has been at the forefront of this conversation. Temple not only values diversity, but Temple also understood that there would come a point in time where the law would change. And we may not be able to exactly speculate as to when, but there was ample signs that there was a shift that was coming. And so one of the things that Temple does primarily is it focuses on doing the work, and that Temple is keenly focused on, one, doing what it can to mitigate the harm that has been done to various communities that create applicant pools for the university. And so there are youth and adult education programming, employment and economic opportunities. advocacy, healthcare, and other types of initiatives that are spawned from the university to directly target some of these issues. Temple is also is keenly aware that one of the ways that it can increase the diversity of its applicant pool is by targeting various communities. And so one of the things that it's doing is looking at particularly some of the neighborhoods and zip codes that feed into Temple and saying, what are ways that we can be a good neighbor to these communities? How can we invest ourselves and ingrain ourselves within these communities so that one, we can increase what some educational scholars call college knowledge of the applicant pool, and that those who are considering a post-secondary education have a sense of what a university or what a college can offer them, what life is like. What can we do to help answer those questions and make them comfortable on campus? How can we establish relationships with their schools and other organizations that service these various communities and the like? And so Temple is engaged in a wide array of activities designed to do just that. Temple just launched a gateway program targeting underserved communities within the area. Temple has just launched a Temple Promise program for those who come from families that earn a certain whose families do not earn a certain amount. They can receive reduced tuition. Temple also has what's called a Saturday school, where middle school and high school students are actually coming on campus and receiving education and enrichment opportunities and the like, as a means in which to better prepare them to complete their secondary education, but also to prepare them for admission to competitive institutions like Temple and the like, and hopefully even to establish a relationship with some of these various students and prospective students so that they can consider Temple as a place for them as they're looking at how they can go about getting their post-secondary education. What other institutions are doing as well. So Texas's program, the 10% program, is still constitutional. So a place like Texas, one of the things that is fortunate and unfortunate simultaneously is that the state of Texas realized that our communities are so segregated that if you admit the top 10% of students from high schools across the state, for the most part, you're going to get a applicant pool that mirrors the overall demographics of the state, because people are housed in these pockets of communities that are very homogeneous. And so the numbers don't exactly extrapolate to that exact proportionality, but they're closer than they have been in times past. So that's still constitutional. And then the other thing is that the Supreme Court decisions, SFFA versus Harvard and versus the University of North Carolina, also still allow students to mention their race, ethnicity, creed, and the like, and their admissions essays, so long as they can tie it to how that portion of their identity is informative to who they are and developing their character and the like. And so there's speculation that some schools are going to heavily emphasize these essays and the like. But there's all types of conversation around that, because some of these competitive institutions are receiving tens of thousands of applications. And so reading through all these essays with a level of attention may not happen at the level that people are speculating, but bless you. But that is ultimately where much of the conversation is right now in terms of specifically looking at admissions. And so some of the strategies, again, they're divergent, but they ultimately have the same goals. One, how can you target a community and meet their needs and to establish a rapport and relationship with a potential applicant pool? Two, things that are on their face race neutral, like this Texas 10% program, are still constitutional. And then there's these efforts around these essays and the like as well. These are some of the things that are being done to help respond to or continue the work of achieving the goals of diversity, and also to mitigate some of these past structural harms as well. The broader conversation around what does that mean for DEI and higher education is still one that's being answered. And in a lot of ways, some states are engaged in actively dismantling DEI and their public sector. States like Florida, Oklahoma, and Arkansas and Texas have defunded or functionally defunded DEI in the public sector, particularly in higher education. So at the state level, we're seeing that happening. Pennsylvania has not gone that route yet. There are debates that are happening in the state legislature around funding around these issues and the like, but they haven't gone to the levels of extremes that some of these other states have. So there's that portion of the conversation just around state funding and state mandates and initiatives. There's this Supreme Court holding that's before us right now. There are other active challenges that are coming before the court, or people speculate will come before the court. And so the short answer is, what does this mean for DEI is that we're still learning what that means for DEI, but particularly in higher education. But the ultimate goal or the ultimate encouragement is for these institutions to find ways to do the work in meaningful ways. It's not just performative or trying to check off a box and the like. But with that said, I wanted to make sure I left time for questions and to have a conversation with you all. I've been talking to you all for a very long time. You all have been very patient and the like, and I appreciate your attention and your enthusiasm. And so I wanted to pause here and see if there were questions or comments from any of you all, ways that we can continue this conversation and the like.
Professor, could you talk more about the reasoning behind why they exempted the military academies?
So the majority decision basically was talking about the need for military academies to be able to recruit and to be able to actively recruit across various communities and the like. Just in a general sense, military enrollment is down across the country, particularly with younger generations. And so that was much of the motivation behind it. A lot of people found that reasoning to be curious at best, but SFFA, the organization, and Edward Bloom, the gentleman behind a lot of their advocacy and its founder, is trying to undo that precedent too. So like I said, we'll see what happens with that in the time to come.
And
So
I was going to say the question in the chat.
yes, that's exactly what I was looking at. So Shana, that is an excellent question. So Shana asks, is the SCOTUS ruling the reason why DEI is being attacked across the country? The short answer is no. So what I would say is that people who are familiar with history, particularly the history of racism in America, will tell you that at every point in which we have made either actual or perceived progress towards racial justice, there has been pushback in significant ways, and to not only cause a regression to the means, but to also just establish the prior social order. And so, by way of example, the era of Jim Crow and lynching followed Reconstruction. So we see an end of slavery through the end of through the end of the Civil War. Then we engage in this radical experiment of trying to restructure society and to give Black people in the U.S. a modicum of rights. And then we have one of the most violent periods in American history seeking to undo that. I say that to say in 2020, we had what many people call a racial reckoning, and that with the brutal murder of George Floyd, that the world saw, the heinous murder of Breonna Taylor, the horrific killing of Ahmaud Arbery, the nation made a commitment to acknowledge its past wrongs and to have a greater awareness around race and racism. And so we started seeing more commitments around DEI and post-secondary institutions, and just the corporate world and the nation as a whole. Increased conversations around race is why we started seeing a lot of these books that are now being banned becoming bestsellers and the like. And it was immediately in the aftermath of that we began to see a coordinated campaign to undo that. So what Nicole Hannah-Jones will tell you is that a lot of it even kind of predated the racial reckoning of 2020, because when she released the 1619 Project, there was an immediate backlash, and the Trump administration, for example, released the 1776 Commission, and which released a report and an ultimate project around it. But a lot of the intensity grew post the summer of 2020, when we saw the moral panic around critical race theory, which then morphed into the moral panic around DEI. And so the Supreme Court decision gives a legal cloak to an attack against DEI, and it gives a sense of objectivity because I'm just following the law as the notion, but ultimately a lot of these attacks are centered in that. And so I know that was a long and meandering answer, but I think it is important to connect these things historically to a broader sense of things. So Ben Hamilton asks, have you noticed any attacks on alumni affinity groups at Temple or any other institutions? So at Temple, I've heard rumblings around some of the affinity groups and the like, but the affinity groups, at least my understanding, are still going strong and still have substantial support internally within their organizations themselves, and also more broadly across the university. I am seeing and hearing more attacks against affinity groups across the country. A lot of them are designed at attacking first their programming. Who are you bringing to speak on campus? What types of programming that you offer? So, for example, you might hear things like, there's some schools that have had Black graduation, so to speak, celebrating some of their Black graduates. Some of those are being banned from various institutions that are in states that are banning DEI and the like. And the idea is that it's on its face some form of racial discrimination, but people who are familiar with those programmings understand that, one, it doesn't exclude anyone from attending. So anyone can attend these events. But beyond that, these things emerge as a means in which to offer support and encouragement in a group setting to those who historically had experienced various forms of discrimination and antagonism on the campus. And so that's why they exist. But so I say that to say that there has been some rumblings here and there on Temple's campus, but overall, I'm still seeing a good amount of support and the like. Janice, do you see things swinging back in the future in affirmative action, or a variation coming back into law? So I would hope so. And I often encourage people not to lose hope that we can continue advancing towards progress and achieving some modicum of equity. And so there was a period of time where people thought affirmative action wouldn't come. There was also time where we thought we wouldn't see the end of Jim Crow or see the end of slavery. And so all of these institutions were undone in part because of the resolve of people who wanted to see a more equitable society. Some of them didn't live to see what they fought for, but they still fought for that anyway. And I think that that's the motivation that we should have too, just knowing that we should continue doing what we can as a society to be more equitable, to both work towards mitigating the harm that's happening in the present and also the harm that has happened in the past, particularly as they overlap. And hopefully we will see a return to something like what we had, if not a better version of it. So many of my colleagues don't share my optimism, in part because there has been a dramatic turnover in the federal judiciary. And so both the composition of the Supreme Court and just federal courts as a whole have been radically altered in the last 8 years or so. And so as a consequence, really in the last 4 years, the last administration appointed more federal judges than the prior two. It's not combined, but more so than the prior two. And so I say that to say that, like, everyone doesn't share my optimism, but I do think that this is a cause worth fighting for, worth advocating around. And right now that might mean these workarounds that people are creating to help solve and deal with this problem until we have a broader policy that deals with it.
So kind of speaking to the advocacy piece that you were just talking about, are there things that Temple alumni can do that they should be sort of aware of in the kind of just in the ether that they should be paying attention to vote on or to write to, or anything within the school that they can support, any areas, just anything that Temple alumni can do to support that?
That is a great question. I'd first say that the state legislature is going to convene soon about funding for higher education, and also just some of these initiatives. To some of Temple's administration is going to be at a hearing around some of these things. And so it's worthwhile to reach out to your elected officials and let them know that you value policies like affirmative action, you value a commitment to diversity, things like that. Temple has a robust offering of various programming and the like that is targeted towards mitigating these issues. And so I can circulate that to you or Kaiser, so you all can get so you can circulate that to the alumni base, so people can find ways that they can be involved, especially if you're local. And for those of you who aren't local, just to continue to find ways to engage in your alumni chapters where you are, and potentially support owls where you are, and also potential owls as well. And so that's something that I did pretty extensively before coming to Temple, just working with young people and helping prepare them for post-secondary institutions. And you'd be surprised the impact that has. There's I still run into students that I used to work with when I was a college student who say that you worked with me when I was in high school or middle school, and that changed my life. And so so I said that to say there are a host of different ways. I will send you all some of the programming that Temple is a part of, so you can see that as well, and potentially become a part of it.
Great, thank you.
You're welcome. Chris.
Yeah, hi. I'm curious about who your office advised.